of employment applications in the Timothy Eyman case. Let me start out with appearances. Let me start with the state and the UST.
Linda Dalton, representing the creditor, State of Washington.
Susan Edison, representing the State of Washington.
Marc Smith, representing the United States Trustee.
Larry Feinstein, attorney for the debtor, bankruptcy attorney.
And Joel Hard, I was seeking appointment as special counsel for the debtor.
Thank you. All right, I've read all the new submissions. Happy to take additional argument, although I'm ready to rule on this. So you can keep it short. I mean, it might influence something, but this is the third hearing on something that's normally done ex parte, so I'm not really that desirous to dragging this out any further. All right, Mr. Feinstein, it's your professional set of applications. I'll start with you.
Well, I'm not going to reiterate everything that we said in the memorandums and the brief. I'm just going to reiterate that for today's purposes, for Section 327 to be disinterested, I think that the proposed order that we submitted to the court meets the necessary elements for disinterestedness. In other words, we don't represent any of the creditors in the case. We don't have a conflict of interest spatially. The issue of whether or not some donor 2 years ago gave $20 to the campaign, and I happen to know that person. I don't think that even becomes an issue because that person isn't a party that would be have a conflict with the estate. So the donors don't have an interest that would disqualify counsel because they're not an interest adverse to the estate, which is required under 327. We proposed in our order that we would give all of the donor information to the U.S. trustee in raw format. I submitted just an example of half a dozen checks showing the court what they looked like. They're made out to the Tim Eyman Defense Fund. They're for $20, $30, $50, and we have hundreds and hundreds of those. We provided the trustee, I think, 500 or 600 checks that go back at least 6 months. We had a discussion last time about whether or not we have to, under FIFO, first in, last out kind of thing, we have to go all the way back to 2007. We contacted our bank. I provided the information both to Mr. Smith and to the state that the bank said that their quick review showed that there were thousands of deposits over that period of time. They want $3 a check to photocopy them. So that would be $6,000 to $7,000 in photocopying costs from the bank. Let's see, our bank allows us to go back 6 months online. So we can go back 6 months, which we provided 500, 600, 700 checks to the trustee for their review to go all the way back to 2017 when the two accounts were set up. And there's 2,000, 3,000, 4,000 deposits of $20, $30, $50, $100. They want $3 a check. So we made a proposal just now, and so I don't think they've had a chance to actually talk about it, that we could provide that information to the state in kind of what I called an in-camera review. They could come to my office and look at all the raw information. If they think that some issue of disinterestedness is reached, they could bring it back to the court some other time. But under the confidentiality that we're seeking, they can't disclose who those people are, and it would be like a non-disclosure agreement type of thing if they want to actually sit down and look at the checks. We'll provide the redacted ones, but if they want to see the actual checks, under some kind of non-disclosure, we've made that offer, and I don't know if they've discussed that or not. But for today's purposes, I think we set it out. I think we made it clear, and in fact, we attached 20-page notes of the commission, for the Public Disclosure Commission, where they acknowledge that legal defense donations are not disclosable, that they're not disclosable under any regulations right now. They've been discussing for years. I think the minutes indicate they've gone back to 2011. So for 8 years, they've been talking about whether or not they should be disclosable or not disclosable. And the state admits in their reply memorandum to the court that they are not disclosable right now under any state or election campaign or finance campaign. So people give to us when we said that your names will not be disclosed, knowing also that there's no state regulations. We have two accounts. We have our initiative accounts, and those are reportable and disclosed, and on the whatever day of the month, every month we have to disclose to the state names, addresses, amounts, everything. So people give $100 to that account. They know that their name, address, and everything will be given to the state and public in that disclosure form that's filed every month. But if they make the election to the Legal Defense Fund, they've made that election under the statement that their names would not be disclosed, and under the state's own regulations that they're not disclosable, and even under like the minutes of the commission's meeting that they know that they're not disclosable, and they're talking about changing those regulations, but to date they haven't done that. So out in the public, the public is making that decision. I'm going to give to this fund, or I'm going to give to the initiative fund. And they might give to both. They might write 2 checks for $20 each, $20 here and $20 there. And they know I'm going to be disclosed over here, but not disclosed over there. So I don't know that a 327 should supersede what the people who gave expected and what the state expected. The state expected that those funds would not be disclosed. And they've had years of committee meetings on whether or not they should make them disclosable so that it's published, so that people who give know that they will be disclosed. And then they can make that decision rather than we making that decision. So I think for today's purposes, I think the court can find under 327 that I don't hold an interest adverse to the estate. I don't think there's any adverse interest for a donation anyway, because that's not a party that's adverse to the estate. It's not a creditor. It's not a party as defined under 327 under the disinterested test. And we point out, I know that we went back to the Supreme Court case, but there's so few cases on this thing. On the NCAA case back in the 50s, that you don't have to disclose who your members are, who people who donate, people that attend your meetings are private. You get the right of privacy, the right of assembly. Supreme Court ruled on it, said, so people that want to associate with Mr. Eyman, contribute to his defense, right of privacy, they expected the right of privacy. The publications in the state say that right now there's not disclosable. They know that it's not disclosable. I don't think that for a 327 order for today that we should supersede that. And that's what we were trying to point out in the memo. So we've given the court our solicitation letters. We give the court a sample of what the checks look like. And I mean, hundreds of them, and they look just like that. The Legal Defense Fund, $20, $30. I think there was even a $100 one in there. And some of the case law on the rights of privacy, and the state's own Public Disclosure Commission minutes where they discuss this. And for years they've been discussing it, and they haven't changed the rules, and I don't think that we should change the rules today in a 327 type of hearing that supersedes what the public expects. So we're asking the court to review the order that I submitted as a proposed order. We'll provide it to the trustee. The trustee can look at the raw data. Every month, they can look at it. And if some conflict seems to arise down the road, and I come back up here for a fee request, and the court finds that I wasn't disinterested, I know what the penalty is. But I don't think that should preempt my application.
All right, thank you. And Mr. Art, I assume Mr. Feinstein spoke for you as to that. You don't have anything to add on
Yes,
this
unless
one?
there's anything in particular you'd like me to
All right,
address.
that's fine. All right, let me hear from UST or the state. I don't care who goes first.
Good morning, Your Honor. Martin Smith for the United States Trustee. Well, I would disagree with Mr. Feinstein a little bit in the sense that I do think Section 329 on its face requires disclosure of the source of money being used to pay attorneys, that it be filed, and that if it's filed, then you fall over into Section 107, and where the court would have discretion not to allow the filed document to be public, to have public access to that. Nobody made the argument about 107 and limiting access to the public. But what I'm really here for is just to offer the court a little bit of factual information about the donor list if the court was interested. We have had an opportunity to take the checks that were provided, put them in a spreadsheet, and
And do you have them unredacted right now? You have the names back to September or whatever the list goes back to?
June.
The period covered by the checks, this is only one account. Mr. Feinstein has indicated there is at least one other account. So I believe we only have information on one account. On that account, it's for April 12th, 2018 to November 28th, 2018.
All right.
It has 508 donors with 634 donations. So there were multiple donations by individuals. The biggest total donation by any one donor was $3,000.
And that's multiple checks potentially?
That's three $1,000 checks, a total of $3,000.
And did you have a chance to check that party's not a credit? I mean, it's a very small creditors list here. That party's not a creditor, at least per the schedules.
I did not cross-check to see whether that party was not a creditor. I mean, from that one individual, you drop down to one individual who gave $2,000, and most of the 634 donations are under $200, so they're very minimal amounts, which really doesn't raise any conflict issue.
And then it's diluted further, if I can use that term, by the fact that by the time these retainers were funded, that pool of funds had been reduced somewhat. So it isn't like $3,000 of the total retainer funds had come from this one individual, because it was way below that by that point.
That would seem to be correct, Your Honor. I will add the caveat that the state has told me that with respect, there have been other donations, I guess, with this other fund, some in very large amounts. We have not seen that, and we don't have that documentation.
All right, thank you. Ms. Dalton?
Good morning, Your Honor. Just a couple of points, because I appreciate that you read everything. I think there's a couple of really important points to consider as you decide how to go forward with this issue of the donors. There seems to be an apparent misreading of the state's position with regards to this issue of the confidentiality of donors. Mr. Feinstein said the state admits that they're confidential. That could not be farther from the truth. There's actually no law that says these funds and the donors to them are confidential. What the state said is the Public Disclosure Commission doesn't regulate them. That's a far different statement than saying that they're confidential, and the state agrees with that. In fact, the question that you posed to the parties, and I believe you didn't get an answer that supports the issue of confidentiality, the reference to the NAACP case, you have an established group with members who provided detailed information about the economic reprisals they had, the loss of employment, the personal threats. You don't have any data here that would provide you even a bridge to considering the NAACP case, and as well as the Doe versus Reed. So what you're left with, for the purposes of the confidentiality question, is Mr. Eyman made a promise to people that he would keep them anonymous. That was before he filed bankruptcy. We could not find any legal support. He doesn't provide you any legal support that promise he made had any basis in the law. So at this point, then he steps into the bankruptcy arena and the bankruptcy rules take over. And the question that you're faced with now is, and we would ask that if you're making a decision to actually determine that his promise to anybody who he again jumps without any evidence, this argument that these people gave because they were going to be anonymous. You don't have anything to support that at all, including Mr. Eyman's own declaration to that effect. So getting back to what the 327 question is, what you have is information, as I believe Mr. Smith talked about one account. And what you have is the one account had, I think we said like $327,000 in it. You also have the representation that during the period of the litigation, Mr. Eyman was spending upwards to $80,000 a month. Clearly, that account would not support that level of spending on legal services. So the legal services he was getting was coming from other funds. It had to be in order to meet the numbers that they provided you. So the caution that we would have is one account doesn't necessarily tell you the whole story. And it shouldn't. So that when we were here last time, that you had indicated that the various funds that made up the payment of the legal services is what you were interested in. And this one account and the small checks from one account shouldn't be the end of the story. We know from the recent monthly operating report that was filed that there was an individual who gave $10,000. And we don't know, because it hasn't been provided, what the amounts prior to the one account were given. And so we would expect, at the very least, that the court order that all of the different accounts be provided so that an actual evaluation under 327 could actually occur. That's what I believe that you talked about at the last hearing, as the source of these funds would be what could be vetted. Mr. Feinstein is right. He just talked to us just moments ago about the possibility of a different kind of review for the state, and we have not had time to discuss that any further. But what we would ask is that any account for which funds came, that there be an identification of the sources of the funds paid for the legal defense, whether it be from an account labeled the legal defense fund or not, and so that there could be a true vetting for disinterestedness. And unless you have other questions with respect to that.
Thank you.
Thank you.
On January 17th, 2019, I set this matter over for further hearing on the applications of Feinstein and Vortman as General Bankruptcy Counsel and as Special Counsel, with Sword and Patton on tax matters and Joel Ard on certain litigation matters. I had previously issued an oral ruling approving the Feinstein and Lessard aspects of the application, but on January 17th, I continued hearing on the Ard application. At this January 17th continued hearing on the Ard application, it was disclosed that not all the donors to the so-called defense fund as the source of all counsel's retainers had been given to the United States trustee, and Mr. Eyman asserted that governing law made disclosure of the donors' names confidential. I continued hearing on all three applications for further submission on the donor disclosure issues. This case raises unique issues due to the source of the retainers. On further review, I've determined that the donor confidentiality issue does not need to be completely resolved at this juncture. As I will discuss momentarily, I will approve all three applications and will not require further disclosure at this point beyond what's already been provided to the United States trustee and proposed in the form of order from Mr. Feinstein, as such detailed disclosure is not necessary under FRBP 2014 as opposed to eventually perhaps under FRBP 2016 for the fee applications. Additionally, although state campaign finance law may well not require disclosure of legal defense fund donors, the law cited to me does not convince me that the disclosure of applicants' names in this circumstance is protected from eventual disclosure. That's not to say I won't be sensitive to disclosure of something that doesn't necessarily need to be disclosed, but I don't need to determine that fully right now. This may be an issue in discovery to the extent the names of the donors are relevant to a contested matter or adversary proceeding. Employment of professionals for bankruptcy estates is governed by 11 U.S.C. Section 327 and Federal Rule of Bankruptcy Procedure 2014. Under Section 327A, a debtor in possession may employ, quote, one or more attorneys, accountants, appraisers, auctioneers, or other professional persons that do not hold or represent an interest adverse to the estate and that are disinterested persons to represent or assist, close quote, the debtor in possession in carrying out the trustee's duties under the Bankruptcy Code. Under Section 327E, the debtor in possession may also employ for a specified special purpose other than to represent him in conducting the case, quote, an attorney that has represented the debtor if in the best interest of the estate, and if such attorney does not represent or hold any interest adverse to the debtor or the estate with respect to the matter on which the attorney is to be employed, close quote. Under Rule 2014, debtor's application must include the reasons for the selection, the professional services to be rendered, any proposed arrangement for payment, and by verified statement, all the person's connections with the debtor, creditors, any other party in interest, their respective attorneys and accountants, the U.S. trustee, or any person employed in the office of the U.S. trustee. Close quote. All three applicants have satisfied these requirements by their verified statements, and each applicant has submitted applicant has submitted a declaration indicating that they have no known conflicts or undisclosed connections relevant to the applications. Local Bankruptcy Rule 2014-1 also requires disclosure of the sources of payment of compensation, including retainers and third-party contributions. The purpose of the local rule is to elicit sufficient information for the court to determine disinterestedness for general counsel and lack of related conflicts for special counsel. Although the source of the retainers has been identified generally, here the individual donors have not been identified. However, given the almost de minimis amount of the contributions from any one donor to the now depleted defense fund still existing as a partial source at the time the retainers were paid, and the representation under oath of each applicant as to conflicts, I find the application sufficient for purposes of the local rule. Council may have to address more specifically the sources of payments as required by FRB 2016 when fees are applied for, and should be aware that any non-privileged relevant information may be subject to disclosure for a contested fee application or other appropriate matter as the case evolves. I conclude that each applicant has met the requirements of BR 2014 and each appears to be qualified. As to the Feinstein firm, I conclude the firm is disinterested as required by Section 327A, and as to special counsel, conclude that neither holds an interest adverse to the debtor or estate as to the matter for which employment is sought as required by Section 327E. The applicant should submit an appropriate form of order accordingly, although, as pointed out by Mr. Feinstein, he is still offering as an appropriate proposed order the earlier proposed order that was at docket 45. So let's discuss that a minute. So the recital paragraph will have to be updated a little bit to indicate the further hearing today. It only references the January 17th hearing. the references to continuance of Mr. Ard's application probably needs to be adjusted a little bit too. Just to be updated.
This is what I changed at your request. The judge's proposal has this in it.
That's what
So then your last paragraph doesn't really track what you're orally really proposing at the moment.
I'm hoping you're reading the same one. Mr. Smith asked me to make a couple of changes to the last paragraph on page 2, which I did, and I think your copy has the trustee's proposed language. If on line 17 it says, by January 18, 2019, and shall provide a list to include. So that's new language that I added in. And then at 19 there was a comma that says, and the amounts paid by said third-party contributors and supporting documentation. I think I added both of those in if the court's reading the revised.
I'm not seeing and supporting documentation. I'll read literally what this says in the last paragraph because, again,
I'll just make sure that it conforms to what I thought I submitted.
Well, I think it's going to raise some issues, so let's just have that out right now. Ordered that any funds paid to the debtor by third parties for legal defense that made up the pool of funds paid to the various attorneys herein shall be reported to the United States trustee by January 18, 2019, and shall include the names of the third-party contributors, the dates of payments, and the amounts paid by said third-party contributors. This is a continuing obligation of the debtor through the term of the bankruptcy. So the one caveat I would see there is you've already told me it would cost you $3 a check to get anything that's older than 6 months. So I would think this needs to be limited to 6 months.
I have just a question on Mr. Smith and I have been arguing about a little bit is when we provided the copies of all the checks that have the names, amounts, dates, whatever, isn't that a list? He wants us now to put that, and there's hundreds of them, into like an Excel spreadsheet with their names, addresses.
Yeah, no, I'm not going to require that, but this is offering more than you're actually offering is you're saying you don't want to go back further than 6 months because it's going to cost you $3 a check.
Yes.
And I'm not going to require that. So I'm saying this should be limited to going backwards to that first date you could get the checks for free.
Yeah.
And the copies of the checks with all that information
All of
to
those
the
checks
U.S.
have been
trustee
provided. The full check, unredacted,
is
names,
sufficient.
addresses, amounts, dates, and we said that's the list. And Mr. Smith says, well, that's not a list. So it isn't the
Well,
check
I mean, that's a
list.
convenience issue between the parties. It provides you all the information that he's promised, correct?
Well, Your Honor, at the time that this came up last time, we were in the middle of a shutdown, and we had 600 checks sitting somewhere in our office that were not categorized or organized in any way, and we didn't have the staff to do that, and I wanted Mr. Feinstein to prepare that. We've moved beyond that. We now have put them in a spreadsheet. We've spent that time, so we don't need that list any further. I would like, going forward, that if there's a significant number of checks that are being provided going forward, that there be a list. But again, that is a convenience item for our staff.
All right. So let me emphasize again why I'm approving it as you've presently proposed. Is I'm not saying you had a legal duty to even propose it the way exactly you proposed it, but since you offered it, you can't take it back. It's just part of what the application is at this point, is that you propose to give that information to the U.S. trustee. I am not requiring that information at this juncture to go to the state, but as you could hear from my comments, I don't think it's confidential either. So if there's a discovery request for it that's, disputed, I guess I will have out that confidentiality issue. I'm not sure why the state needs those names at the moment. I will throw that out at the moment, because for my purposes, what I need to see and why the rules require in general this sort of information is so that I can make sure that the conduct of the estate by its professionals isn't being directed by a creditor or party in interest. And I don't consider donors that aren't otherwise a creditor to be parties in interest. Now, if you had some other odd turn of events, I can't even come up with the right scenario. I mean, I could assume if a donor thought they'd been frauded, they could be a creditor, but then they're not going to be contributing to a legal defense fund either. So I can't off the top of my head come up with a scenario where the disclosure of the name is actually going to be all that crucial to see whether there's a conflict of interest or a lack of disinterestedness. Where I think it has helped your application to offer what you have offered to the UST is to show me that we don't have some big sugar daddy here that is in effect directing the legal operation of the estate by the purse strings. And that this is really a pool of relatively small donors, not implicating the issues that 2014 is trying to get to. But again, that's a far cry from saying these are confidential. But if the state's going to request them, I assume there's going to have to be a relevant purpose for it. So I would say the adjustment in that last paragraph, certainly any new contributions that come in, all that detail needs to be given directly to the UST, and it's going to be very relevant for any 2016 applications for compensation. But I think you've indicated a limitation to only go back 6 months on the donors so far, and I think that's acceptable under the circumstances, because really what I was trying to get from that list was, in essence, the de minimis nature of the contributions. All right, any question on that from anybody? You probably don't have do you have the benefit of having the document in front of you?
No, but it probably, given the fact that you've indicated that there needs to be an update to the recital and a couple of other areas, what I would suggest is that the order be resubmitted with the changes that the court has expected.
What I would prefer, though, is to have a situation where I'm not going to need to have yet a fourth hearing on all this for presentation of the order. Ms. Kelly, will you let Ms.
we would
Dalton
just ask
see
that
this order? So why don't you peruse it really quickly? I just want to save time here.
Sure. And
I don't think there's going to be any controversy on the mechanical changes to the recitals.
So the only other question that the state has with respect to the application process and the appointment deals with Mr. Ard and the fact that he is no longer counsel in the state case and has obtained a court order to withdraw, what the court's expectation about his conduct going forward with regard to being appointed by you to protecting the interests of the state. So,
well, because he's special counsel, as he sits right now, at least from my, perspective, he doesn't have any duties other than his duties to represent the estate in the matters that he got employed. But because he's withdrawn now successfully from the one matter he'd appeared in, I off the top of my head, I don't know what the consequence of not following through. I think it would be healthier if he did follow through and go through the local procedure for withdraw in this court from the representation.
Your Honor, we've got that document ready to file. I thought it was prudent to be appointed before I withdrew.
That seems
So
reasonable to me.
Likely within 24 hours.
I think with following that process, I can't imagine I wouldn't let him withdraw. I can't even dream up what the reason for that would be at this point. And then I can't imagine what any further ramification from it is. He will be allowed to apply for his fees, assuming otherwise complies with 2016. BR 2016 for his work up to the date of withdrawal?
The state was just trying to determine what its responsibilities were as counsel for the estate with regards to notice of proceedings that are going on in that case, that type of thing.
If he's withdrawn from your case in Thurston County, I assume he doesn't get notice of anything anymore.
Okay, so I just want to make sure you have no expectation.
Right.
That
If you were going to take some action regarding him that affects him in the bankruptcy case, subject to his fee application, whatever, he'll get notice of that, of course. Right. But no, you have no further duty to treat him as if he's still in the Thurston County matter when he's not in the Thurston County matter anymore.
Thank you. We wanted to confirm that.
All right. Go ahead. I'll still give you a quick minute to peruse these. I don't think there's anything heavy in the recital.
Yeah, but he said some of this recital needed to change to some third date. January 31st. Right. And then send that. Personnel about word. Yeah, because it says. Hey, Larry. Larry.
Let me give you a minute. I'm going to take.
If you don't mind.
Let me take till 15 after and come back out. And Mr. Feinstein, let me give you a forewarning too. Since we're still in the early stages of this, I haven't set this for a 105 conference. I'd sort of like to avoid the expense of that, but I would like to have a bit of colloquy when I come back out on the bench of timing, where you expect the case to be going. Because I had thought earlier on we were right on the eve of a trial in state court, but it sounds like that's not at all the case. So you're going to be in a long period of time prior to any judgment from the Superior Court, I think. So I want to talk about timing of the case in general when I come back out. Thank you.
All right.
Okay, so he said.
Where are we at on the form of order? I mean, I don't need you to have worked out every word. I just want to make sure that there's not any big issues to discuss.
I just did go upload it.
Okay, you're ready to upload it.
Yes, well, we've marked it up. I'm going to go back to the office and we're going to.
All right, great. So let's turn to the other matter. This isn't a formal 105, but I need to get some sense, just for case management purposes, of where you see the case going, timing-wise, and what you're hoping to accomplish.
Where he's sitting.
You can pull up a chair and sit there as well. It might be more efficient.
Testifying, or what am I doing?
Yeah, that's no, you're not testifying. This is not.
Sorry.
This is not an evidentiary hearing. In fact, this really isn't a hearing. It's more of a impromptu status conference. In lieu of hauling you all back in for a formal 105 conference, it'll save a hearing.
Is it?
Okay, Mr. Feinstein. So you know what I normally am looking for in a 105 conference, just direction of case and timing.
Well, we've already started to move it along. I think we've already submitted to the court a claims bar deadline, and the court has issued that. We send it out to creditors. We're going to see what the claims are.
And I don't think I've signed that. What are you requesting in
I thought
how
it was
far
March
out?
something.
All right. So, I mean, normal time frame, 60 days.
Yeah, 60 days or something.
Right.
I thought I submitted a claims bar giving 60 or 90 days to see what the claims come in and look like. And then our intention is we were not going to drag this out till 2020 in the bankruptcy. Trial with Mr. Eyman is set for up to like 2020 or January or February or something. Our intention is to have a plan filed that will then have provisions that if there are monetary awards against Mr. Eyman, those awards will then just plug into an existing plan. And the plan will have a provision for either the liquidation of assets or payment of claims over the normal period of time that may be provided in a plan. So we're going to hope to have a plan filed without coming into court and say, can we just put this case on the back burner until 2020? So what we talked about was wait till the claims bar deadline, see what the money claims look like. The state has other relief requested that are not money claims, and that's just going to have to go forward. But we'll try to deal with the money claims, which are the bankruptcy, in a plan. So it's going to be a kind of a that's what we're intending it to look like. Yes. And there's also an order.
Motion.
There was that second lawsuit. Is that what it was?
No, may I?
Yeah, go ahead.
Very good, thank you. Tomorrow I have a motion before the judge, motion to default. So the effort is to not have a trial in January 2020, but to instead simply default on it because I'm without counsel right now and incapable of being able to really intelligently defend myself. So I have a motion before the judge, which the state opposes, where I just say, I default. I'm assign whatever penalty you want. You've already, the $2.1 million that they wanted was for 2 transactions from 6 years ago. They've now expanded the case. They're looking for many more violations, but we're already way past the value of my estate. So my effort before the judge is assign a penalty now because this thing is only costing.
Yeah, I understand.
So very good.
I mean, the timing here can be interesting just because you have the interplay between the claims process, which is quite a bit faster in bankruptcy court, and then pending litigation that isn't stayed. All right. Anything from the UST? I know I just sprung this on you, but I am trying to avoid the redundancy of a 105 conference.
I didn't look about whether we had all the insurance requirements and stuff at this point, but I would have looked at it at the time of the 341 and raised any issues with Mr. Feinstein. I think everything was fine at that time. To the degree it's not, I'll bring it to counsel's attention.
All right. I mean, anything the state wants to say, I'm not really looking to you for anything because more I wanted a heads up from the debtor as to timing.
The only comment that I would make on the timing, the case actually, there are 2 lawsuits. One in which a default has been taken against Mr. Eyman, the tougher to raise taxes case was taken last Friday against him and the political committees involved. So that will proceed through a default judgment process. That isn't set at this point. I mean, the default was just taken. And the second case, the State versus Eyman et al. Case, there are additional defendants there. So the default that he's requested came along with some other relief that the trial court will have to deal with tomorrow. I don't know whether the trial court will actually allow him to default. His LLC is still a defendant in that case. And so that issue will have to be addressed with the trial court. Even if a default is taken, there's a process by which a default judgment would have to be entered also, and that we don't have any idea about timing of that. We'll have to wait to see what the court does tomorrow.
All right. Well, my inclination would be to just let this sit for a moment, whether it's on the docket or not yet. I didn't look, but if it isn't there, I will expect you to your word that you've submitted a bar date order, motion and order, and I'll deal with that. If we get to a point out into the spring where I still don't see a plan and disclosure statement moving forward, I will set a 105 conference for the purpose of setting some deadlines then, but I would say through March, I'll be looking for a plan and disclosure statement, but I'm not formally setting any deadline right now. All right, thank you. We'll be at recess.
All right.
We're operating on